All right, so what's this thing about the other forms of harassment being covered in the model sexual harassment prevention policy? So the policy does clearly try to lump in the other protected characteristics, including these two statements. Towards the beginning of the policy, it now says, while this policy is focused on sexual harassment and gender discrimination, the methods for reporting and investigating discrimination based on other protected identities are the same. In other words, we're spelling out investigation procedures in the sexual harassment policy because we have to, so we might as well let you know that we will follow these procedures if you report any other types of harassment as well. At the very end of the policy, which is 12 pages long, by the way, the policy concludes by saying the prevention policies outlined above should be considered applicable to all protected classes. I mentioned a minute ago that the filing period with the Division of Human Rights is different for sexual harassment and other types of discrimination and harassment claims. The model policy doesn't identify that. However, that is one thing that I would be more careful about than the state apparently has been. If you're going to take this approach, clearly the legislature passed the law requiring a written policy on sexual harassment. Whether the state has the right now to require employers to put language in their sexual harassment policy addressing gender discrimination, even much less other forms of harassment and discrimination, certainly seems questionable. That being said, as we're about to switch to, certainly think it's a good idea to have policies that identify and prohibit the other forms of harassment. But again, that is a component of the model sexual harassment policy that I would question whether employers are really obligated to adopt. And really more importantly, are there other ways of accomplishing the same thing?